Section 111 is a Medicare issue. It is not a Medicaid issue. This new law that went into effect is on everybody's mind. We spent a whole day talking about it. However, parties to a lawsuit are obligated to protect Medicaid's lien as well as Medicare's lien. Medicare has a primary statutory lien, but Medicaid's lien is out there as well. And we as lawyers and as clients or as people who are funding settlements need to be mindful of the fact that Medicaid's lien is out there and it has to be satisfied too. So even though Section 111 is a Medicare issue, federal law mandates that each state Medicaid agency take reasonable steps to ascertain the legal liability of third parties to pay for medical services provided to Medicaid recipients. Just like Medicare, Medicaid is intended to be a payer of last resort, and so Medicaid is also going to come looking for any other available source out there to pay for medical care. Now, each state has reporting requirements. They are sometimes, often, overlooked in the wake of Medicare's super lien, but they exist, and your ability to finalize a settlement and close down a case is going to depend upon your compliance with the state requirements and satisfaction of Medicaid's lien as well. Now, exactly what is required to be reported is going to be different from state to state. However, Mississippi statute is a pretty good example of what I think you can see. As you all know, under the federal law, when a plaintiff receives Medicaid benefits, they are subrogated their rights to Medicaid to recover, and they can't do anything to prevent Medicaid from recovering that lien. Under Mississippi law, a plaintiff can include Medicaid's lien as an element of damage. It is likely going to be couched as plaintiff seeks to recover all past and future medical expenses. And when those medical expenses are paid by Medicaid, then Medicaid has a right of recovery, and they're going to be looking to a third party to settle those. Under Mississippi statute, when is notice to be given? Well, our statute says that when a lawsuit is filed, a copy of that filing is to be certified on the Division of Medicaid, and a notice is to be filed in the court record. Does this happen? Not too often in my practice. Generally, the way it works is I get a lawsuit in, we start doing discovery, I gather medical bills and records, we start going through them, and we determine that Medicaid has paid some portion of the medical, and then at that point, Medicaid is put on notice. But, again, I think for plaintiffs' lawyers, it's to your benefit to go ahead and get Medicaid put on notice early. Our statute, like many, many others, allows for the recovery of attorney's fees, much like Section 111, a defendant's obligation to report a settlement comes in a little bit later. But the penalties for failing to notify Medicaid and to satisfy the lien are troubling.